You're listening to In the Strike Zone. I'm Jessica Szilagyi, your host, and again, this week we're talking about a single issue. This week, it's ballot access. This is yet another important issue that I feel like education puts people in a better position to have an opinion about, and ballot access is really important to me. One, as somebody who doesn't associate with a political party, and two, because it's imperative to our representative constitutional republic. So, and another reason is because there's so much misinformation about it. I posted an article a few days ago about the Libertarian Party of Georgia lobbying for ballot access in our state, and someone commented about voter ID. They said that we shouldn't make it easier to vote without an ID. I kid you not, this really happened. So I'm going to start off by explaining what ballot access is, since it's not the process of obtaining a ballot to cast a vote. So what is ballot access? These regulations that control who appears on our ballot, they're known as ballot access laws, and they determine whether a candidate can appear on a ballot, how they get on the ballot, what they have to do it, and these laws are set at the state level, and they apply usually to state and congressional candidates. The states often delegate a lot to the local county board of elections, and they set rules too, but a lot of times people run in nonpartisan races, so it doesn't at the local level, so it doesn't always apply as much at that level. Most states and candidates and parties that have not previously garnered a significant number of votes at the national level and wish to appear on the ballot have to collect signatures. That is the percentage of the total number of registered voters. It depends on the state, it changes, and we'll get into that, but the requirement puts these third parties like Libertarians and Independents and the Green Party members, and even someone who wants to just run without a party, it puts them at a disadvantage. Some states impose filing fees to cover the cost of the ballot process to get them on the ballot, and that's extra burdensome because the incumbents or those backed by a political party like the Republican Party or the Democrat Party usually have more money and resources to devote to the cause. But what do Republicans and Democrats have to do to get on the ballot? All they have to do is show up, especially in Georgia, they show up at the Capitol, pen a check to their respective party, and that's it. So there's definitely a different threshold for ballot access, specifically in Georgia. It is a problem, even though it's not as bad at the local level. It is a problem at the local, state, and federal levels. The United States is the only nation in the world, except for Switzerland, that does not have uniform federal ballot access laws. Now, I'm not for a ton of laws at the federal level, but if you're not going to use the Constitution to protect individuals from getting on the ballot and from having undue burdens that their peers don't have, then perhaps it's time to implement some sort of universal standard of equity under the law. This guy named John Avlon, he penned an op-ed about it, and he said that these rules, these ballot access laws are, first of all, they're written by the people who they stand to protect. The Republicans and Democrats in the state legislatures, of course, they want to protect themselves, they want to protect their seats, and then they want to protect their friends that are in Congress and running at statewide levels, and if they plan to seek higher office, they don't want voters to have more choice. So, of course, they're going to protect the system that protects them. But this Avalon gentleman in this op-ed, which I will post in the show notes, he says that the rules are imposed by state party bosses who are less interested in democracy than in rigging the system to benefit their favored candidates. I'll let him slide on the fact that we're a constitutional republic, not a democracy, and he slipped up in his quote there because I think his premise is correct. This isn't they're not, these people who set these laws at the state level and even at the national level and the secretaries of state who enforce these laws, they're not interested in representation. They're interested in in making sure that the people they want to be elected either get elected or stay elected or don't have, intense competition. So what have these restrictions done in reality? Well, at a national level, it's hard for third parties to get on the ballot in every state. Libertarians only appear on presidential tickets in 33 states and in D.C. The Green Party is recognized in 21 states. The Constitution Party in 15. And these aren't just in red states or blue states. It's everywhere. And that's like one thing that Republicans and Democrats agree on. They collectively don't want more competition on the ballot. But this isn't just a libertarian thing. I lean libertarian, but this doesn't really have anything to do with libertarians. They are most vocal about it, probably because libertarians are for freedom and liberty for all. But it affects independents and the Green Party and the Constitution. And it affects voters who don't have choices that represent their values. And it hasn't always been like this. It wasn't until the end of the 19th century that state and local governments did not print ballots for elections. Back then, candidates did not have to earn access to be on a government printed ballot. They just filed for office and sought votes. And, today's state laws, like everything else, there's more laws, there's more ballot access laws, and they vary so much from state to state. And in some states, it's nearly impossible for independent and minor party candidates to get on the ballot. In some states, it can be even harder to get ballot access in congressional races than in presidential races, which makes no sense. But then there are states where there are no presidential candidates that appear on the ballot that aren't Republican and Democrat. And a candidate can rarely win an election or even compete if they're not on the ballot. I mean, especially think about someone with the last name like mine, Szilagyi. If that's not on the, you know that name if you're familiar with it, you know it to be something you've seen before. But you show up to the voting booth and you've got to write that in. I mean, it would put me at a disadvantage. And my response to these people who fear the idea of ballot access is, if you're confident in the quality of your candidates, then why are you too afraid to put forth legislation on the issue or let alone put it out for discussion? Why are you so scared? If you are doing right and you feel like you are adhering to your principles and governing in a way that represents all people the best you can, what's there to be afraid of? So, getting back to the issue, why is ballot access a problem? Well, first of all, I'm going to talk about Georgia a lot. I'm going to intermix other states, but because I live in Georgia and it's something that I'd like to see changed here, and I'm going to focus on it. But despite the dominance in Georgia and across the nation, this is why it's so important. In 2018, in the middle of the year, they polled registered voters and found that 25% of Americans identified as an unwavering, always, definitely 100% Republican. 25% of registered voters. So that means the percentage of Americans, even though these people are controlling, they have our presidents, the presidency right now, they have state legislatures all over the country, they have governor's offices, constitutional offices, even though Republicans dominate, 25% of Americans see themselves as unabashed, constant Republicans who would not sway from the party. That's not very much. And a little over a year ago, they polled millennials, which I'm a millennial, not always proud of it, but I'll claim the title. 71% of millennials say they want a third party. 71%. So people, that doesn't even include, couple that with all the people who don't identify with the party, or the people that do identify with a party but don't vote straight ticket. I mean, open-minded people want more choices. People who aren't blinded by party loyalty want more choices. So that's one of the reasons that ballot access is so important. The other is, according to Michael Porter and Catherine Gill, they wrote in September 2017 in a white paper published by Harvard Business School that confidence in our government has declined from 73% in the 1950s to 20% in 2017. So we have a low confidence in our government, yet we're choosing not to put more choices forward for people to possibly have better government, if government can be better. I believe it can. I believe if you had candidates that believe in freedom and liberty and individualism and all these things that the other parties say they stand for, if you actually had diverse ballot choices, we might have a better more representative government. But so all of this is contributing to the dissatisfaction and dysfunction and of the two parties that write the election laws. But luckily for us, these laws have made their way through the courts a number of times. Now, just like every other issue, the courts have teetered back and forth on what they actually come forward to. But one, I think it's reassuring that these issues continue to cycle through the courts. And two, I think it's important because in some instances, the courts make a ruling and then the states are forced to change their laws. So let's just kind of run through a few of the laws over the last several decades because it's important as we look at the laws going forward. Courts have ruled that the government's authority to regulate elections cannot make ballot access unduly burdensome. There's a 1972 case, Bullock v. Carter, and it said the U.S. Supreme Court found that the payment of a filing fee to run for office was unconstitutional. Although the court based its ruling on the Equal Protection Clause, it also discussed how the fee affected conduct protected by the First Amendment. Now, you heard me say in the beginning of this that, Republicans and Democrats pay a filing fee and they qualify. Well, it's not technically a filing fee that goes to the state, especially in Georgia. That filing fee goes to their respective political party. So they're advancing the cause, they're pledging to uphold that political party's values. If you're a Libertarian or a Constitution Party member or a group, another candidate or another party, you pay a fee to the state to get on the ballot and to help cover those costs. And this is kind of like the whole debate thing that we see during the presidential elections where they don't let the third party candidates on the stage, but taxpayers are funding these debates, but they're limiting the people who are on the stage to Republican and Democrats. It's just like that. So anyway, in 1968, I got a little bit ahead of myself, but there was another case in William v. Rhodes. The Supreme Court used the Equal Protection Clause to invalidate the state laws, which means everyone's equitable under the law. You can't set different standards for different individuals, which is exactly what is happening with ballot access. 1983, Anderson v. Celebrezze, the Supreme Court invalidated on First Amendment grounds a state law that imposed early filing requirements for independent presidential candidates who wish to appear on the general election ballot. So in a lot of states, not only do these candidates have to collect signatures and pay a different fee and, jump through these hoops, they also have to do it earlier than the other candidates that don't have to do any of this stuff. And so the courts in the 80s found that that's not correct, and it's a violation of the First Amendment, which would be for them to go ahead and begin campaigning. So I think that one's particularly interesting. And then, of course, in 1986, Monroe v. the Socialist Workers' Party, the court upheld a requirement that a party secure at least 1% of the vote in a primary in order to gain a spot on the general election ballot. The court noted that although the 1% requirement did infringe upon the First Amendment rights of the party, these rights were not absolute, and it was not burdensome to require the party to demonstrate some minimal level of support on the ballot. So I'm trying to show you how the courts have kind of teetered back and forth. First they say that these access laws are burdensome, they are a violation of the First and 14th Amendments, and then later on they say, well, they do what courts do, and they say, well, we agree that, it's not right. However, you got to show some level of support. Now, this is me being cynical, but I'm not really a fan of these judges, imposing these types of things. When you look at what they say that you have to demonstrate a minimum level of support to appear on the ballot. Well, why? Who said that? The Republicans and the Democrats don't have to demonstrate anything. So in their very ruling, in this 1986 Socialist Workers' Party v. Monroe, they're teetering even further against equitable under the law. But in some cases, this has actually backfired. Some of the laws at the state level and at the federal level have backfired on Republicans and Democrats. For instance, in 2012, the state of Virginia only had 2 candidates on its ballot for the presidential election, Mitt Romney and Ron Paul. And of course, we could get into the whole nonsense mess of, having early primaries and that system of what states matter for the primary election and not. But we're talking about in the state of Virginia because the campaigns failed to gain a certain number of signatures, which I think was 10,000. And so these presidential candidates didn't actually appear on the ballot, and voters didn't get to cast their vote for the person who best aligned with their values. I will say that Georgia, I was a Rand Paul supporter in 2016, and he was already out of the race by the time I got to vote in my primary, but I still cast my vote for him because the people who were left in the race didn't align with my values. So he at least appeared on my ballot. So I will give Georgia credit with regard to the presidential election, but it was also a primary. But, these laws have backfired, and I can at least appreciate that. So when we're talking about this, I've already slammed Georgia a good number of times. You're probably wondering, well, who is the worst and what makes someone the worst? But that depends on who you ask. There's a group, FairVote. They are big advocates of ranked choice voting and increased ballot access. They say that Alabama, Arizona, DC, Florida, and Georgia are the top 5 in terms of worst states in that order. So Georgia would come in 5th. But the Independent Voter Network, year after year after year after year, has said that Georgia is the worst. So let's talk about Georgia. Georgia has been labeled as having the most restrictive ballot access laws in the country. Independent Voter News, Ballot Access News, they're both independent chroniclers of election laws in the states. In Georgia's petition for U.S. House and the state legislature requires 5% of the number of registered voters. And it's so severe that no legislative candidate successfully used the procedure in the last several years, except for one candidate for state house. Incumbent independents don't need to do the petition. So we did have Rusty Kidd serving in the legislature, but, it was a little bit different. But no independent has successfully submitted the 5% petition for U.S. House in Georgia since 1964. So we've only had Republicans and Democrats on our ballots for U.S. congressional seats since 1964. And back in 1964, the petition wasn't due until October. The signatures weren't checked, they didn't need to be notarized, and no filing fee was needed. So in 1964, it was not as difficult to get on the ballot. But then, of course, they passed a law that made it very difficult. It became effective in 1965. The petitions were moved up from October to July. Each sheet of signatures has to be notarized. Anyone who notarized any of the sheet cannot be on the petition. The fee is equal to 3% of the annual salary of the office. And again, that goes to the state. And no minor party has complied with the 5%. And so it's just, we're not having representative elections. If you look at the numbers of the 5%, in 2012, the number would have been 51,989 signatures. Now, consider that you need 51,989 signatures. You get a window for how long it would take you to collect those signatures. And then on top of that, you have to account for the voter rolls not being accurate and you having bad information and signing someone up having someone sign the petition that isn't necessarily qualified or who would be disqualified, or all these other reasons that the state can strike names. So you have to account for more than the 51,000. It's absolutely ridiculous. Now in Georgia, the Green and Constitution parties sued Brian Kemp in 2012. And they said that there are several different clauses in the Constitution that we feel are being violated. You should have free and fair elections. These parties are on the ballot in 30 and 40 states in every presidential election. Why can't they get on the ballot in Georgia? That was their argument. And the suit accused the state of violating the Equal Protection Clause of the U.S. Constitution, which says that no person or group can be denied legal rights granted to others in similar circumstances. And at one point, Kemp's own Special Advisory Committee on Election Law Reform suggested easing the petition restrictions. But of course, the authority that has the body that has any authority to do anything, the General Assembly, would have had to make the changes, and they chose not to. No bill went anywhere. Of course, Kemp's office repeatedly fought the lawsuit, I think, for all the way up until he left office. And over that time, U.S. District Judge Richard Story lowered the petition, but the Secretary of State's office appealed that. So simultaneously, while they're appealing this decision of the judge lowering the threshold, Kemp's advisory committee is saying, we'll ease some of the restrictions. So they were in direct confliction of what the same office was saying. And that was one of my biggest criticisms of Brian Kemp, was that He spent thousands, hundreds and thousands of dollars in legal fees fighting these battles against ballot access, when in reality, the best thing that could have happened would be for, especially as the Secretary of State, the person over elections, you should be advocating for as many people as possible to appear on your ballot. So in 2000, this suit was filed in 2012, but in 2017, the legal battle is still ongoing, and the 11th U.S. Circuit Court of Appeals in February 2017 upheld the ruling that a portion of Georgia's ballot access law violated the U.S. Constitution, and the AJC reported that the three-judge panel unanimously decided with U.S. District Court Richard Story, who had previously lowered the number of signatures required for third-party candidates to get on the ballot from tens of thousands to a mere 7,500. But then Secretary of State Brian Kemp fought it, never did anything about it, didn't comply with the law. But 7,500, that's still a ton and totally unnecessary, but it's tremendously better than tens of thousands. So I think that the parties who advocate for ballot access, even though they were upset or still are upset that they have to go through different processes, it's still an improvement that they can appreciate. And then the judge sides with them, the Court of Appeals sides with them, and Kemp didn't comply. Georgia's not the only one to take these things to court, though. I mean, there's been lawsuits all around the country. Maryland. In Maryland, they register by party, but third-party candidates are still required to renew their official status every 4 years, either by attracting more than 1% of the gubernatorial or presidential vote, or by filing a petition with the signatures of 10,000 registered voters that state law requires them to collect. But the state's records already show that there are 22,000 registered Libertarians because they register by party. And the party is, in Maryland, the party is asking the court to extend their party recognition for another 4 years without requiring them to do the signature effort because they lost on the 1% threshold, I think, in their governor's race. And I love this. They're suing, and one of their arguments is that, like, the state has crushed a lot of their signature efforts because they say the names are not exact. I mean, we've gone through that in Georgia, the whole exact match thing, and it's similar in Maryland. And their argument is that Governor Lawrence J. Hogan Jr., a Republican, signs his names on the bills and lots of documents as Larry Hogan, which is different than Lawrence J. Hogan Jr. And so they're saying, well, if the governor can do it, why can't we do it? Which I can appreciate, and I look forward to what the judge says about that. In Montana, the Green Party is suing because they say that Montana's qualification requirements for minor political parties are unconstitutionally burdensome. And the lawsuit was filed after a state judge removed the Green Party from the election ballot in 2018, and then more than double the required 5,000 voters signed a petition to put the party on the ballot, but the party fell short of getting enough signatures. So how do you have double the petition of registered voters and still have all of those thrown out? In Maine, this is a really interesting one. They register with the party again. They had 6,168 registered Libertarians, and they're unenrolling them from the voter rolls because according to the state's rules, the Libertarian was no longer a qualified party with ballot access since it failed to have over 10,000 registered Libertarians in the last year election. So they fell short by just like 3,900, 3,840. And instead of saying, well, you guys can still be registered as Libertarians, they're taking them all off the rolls and not recognizing them as Libertarians at all, which is insane. And the Libertarian Party of Maine, they've been vocal advocates against the Secretary of State there, and they took them to federal court to be recognized at all. So this was a ruling recognizing Libertarians as a party for the reasons of the rolls was a court decision in the first place. And so I guess the state didn't like that. And so they're taking them off the rolls altogether. So this case in Connecticut, it's been going on since 2016. I think it's one of the ones I feel like is the most clear about the problems that we're having. A month after the Libertarian Party filed its complaint in court, Judge Janet C. Hall of the U.S. District Court for the District of Connecticut ruled that Connecticut's statute related to signature gatherers is unconstitutional and a violation of the 14th and First Amendments to the U.S. Constitution, which I agree with. Justice Hall, relying on numerous previously decided federal court cases, noted that gathering signatures from potential voters is an interactive communication concerning political change. She further noted that the U.S. Supreme Court has ruled that this type of activity is core political speech, subject to strict scrutiny by judges. Strict scrutiny is the most demanding type of judicial review because of their critical nature, and the laws that trigger strict scrutiny are presumed to be unconstitutional. So Judge Hall further noted, talking about that 1976 case that we talked about, that the loss of First Amendment rights, even for minimal periods of time, unquestionably constitutes irreparable injury. So this is monumental. And what do? The Secretary of State there just decides to ignore it and push on and have I think he's had 2 elections since, and just ignored that ruling. So the problem is that you have elected by party secretaries of state who fight these things in court, spend hundreds of thousands of dollars, again, fighting against more access, and then when the court rulings come down, they just ignore it because, well, they're going to protect their friends. Even still, I don't understand how these state laws have passed the muster of the U.S. or state constitution, which were written on the premise of equitable under the law. And of course, the most important question, how can we have a representative form of government if all of the representative forms of government aren't represented? It's hard to comprehend the mindset of someone who is so set on keeping other people from running against them that they have to cheat to do it, that they have to block people from participating in order to do it. And I guess I can't understand it because I'm not enamored by the idea of power, but it's unconscionable, it's inconceivable that people are willing to do this in an unfair way, that they don't want the people they represent to be able to vote for the people that best represent them, even if that's not them. That would be the definition of a true public servant. Whether they're unelected or whether it's not in their best interest personally, they would want to do the right thing. So how can we fix the system or at least improve it? Well, first of all, the signature requirements, they've got to go. They're prohibitively high. There's 2 ways to do it. One, you can make the GOP and the Democrats do what all the other parties have to do too. I guarantee you that would be the quickest pathway to change. If there was some sort of universal law put in at the federal level that said, the Democrats and the Republicans have to collect just as many signatures as the Libertarians and the Green Party and the Constitution Party and everyone else, you'd see an effort the following year for the signatures to go away for all candidates, which is the end goal. Eliminate it entirely. If one person can show up with a check and get on the ballot, 15 people should be able to show up with a check and get on the ballot. The other thing is, the states shouldn't impose different deadlines for different parties. Just because someone's political beliefs are different than another's doesn't mean that they should have to jump through different hoops. So what can you do on your own? What can you do as an individual? You can contact your state lawmakers. You can contact your friends. First of all, contact your friends and tell them what ballot access is. Of course, you could easily do it by sharing this podcast, but you need to educate your friends on what it means to have ballot access and less restrictive ballot access laws in your state and why that is so important. Then contact your state lawmakers and tell them, because there's a bill in the Georgia House right now, or one that's been drafted, that can't get any signatures because our legislators don't want to sign it because they're too afraid. And it's asinine. So you got to contact your state legislators and let them know that even though you might support them and you might plan on voting for them, you think it's more important to have more representation on the ballot every election, every time, no matter which political party it is, because that's what individualism is about. That's what our country was founded on. In order to protect people's First Amendment rights, their 14th Amendment rights, in order to give the perception, at least, that there is a free and fair election, that the system is not rigged, that they're not tipping the scales in favor of people who are in power already, if people want some inkling of trust to be restored, ballot access can help with all of those things. It just takes educating the public, explaining away their fears, and helping them understand why it is so imperative. So this is the part of the show where I remind you that I want to hear from you and that I want to hear your opinions on ballot access, and I want to hear your stories if you've run for office and had to jump through hoops, if you know someone who has, if you have a story to tell that was horrible about ballot access and why it hurt your state. I want to hear that too. You can always drop me a message on social media, but in order to do that, you've got to make sure that you're following me on all the traditional platforms, Facebook, Twitter, and Instagram, and of course, YouTube. That's all for this episode, though. Thank you for tuning in.